Hi, my name's Shane Foyster. I'm a lawyer at Barwon Community Legal Service. The coronavirus is a health crisis and it has some legal symptoms. We know that many people in our community right now are experiencing legal problems, and we hope that the following information will help you and your family get legal help early. Your boss can make you redundant only if the job you perform is no longer required, or if the place you work for becomes insolvent or bankrupt. So, for example, a redundancy could occur if there's a downturn in demand for whatever it is that the business you're working for or the place you're working for sells. It could also be where your usual duties have been reallocated to other employees. However, it has to be a genuine redundancy. So it can't be that this is an excuse for something else. They have to actually also comply with consultation requirements before they make any of these decisions. And that includes making reasonable efforts to redeploy you to another part of their business. Now, if the redundancy is genuine, they also still have to pay you appropriate notice, redundancy pay, and any other entitlements that you're owed. Yes, the workplace can stand down some of their workers for a period of time where there's a stoppage of work which the workplace couldn't be held responsible for. So an example is that the workplace is temporarily forced to close their business to comply with the COVID-19 government restrictions, where there's a large portion of their workforce that has to self-quarantine and the remaining employees can't actually do their job. Now, those sorts of examples would fall within these stand-down rules. However, you need to know that before they make that stand-down decision, your workplace has to consider alternative options for you. So this means, can they redeploy you to another position, even if it's a lower level? They have to consider this. Could they just change your hours or your roster? Could they modify the usual work that they do so that you and the workplace can comply with social distancing? Could you just work from home? Employees also have a right to what's called flexible work arrangements, and they have to consider that, and they also have to consider, could they just give you accrued paid leave, like your annual leave? Now, it's important for you to know that the effect of a stand down is that you still remain employed. However, you're not required to perform your work, and you're not paid. Because you're still employed, you do accrue annual leave and you do get personal leave entitlements even while you are stood down. Well, firstly, you can use up your personal paid leave. So if you have any symptoms that you're worried about, it could be a temperature, cough, runny nose, even if it's not COVID-19, you can still just get a medical certificate, show that to your workplace, and you should get paid. If you're a casual employee, you're not entitled to paid personal leave, but you still shouldn't be dismissed because you've done the right thing and stayed home. Now, if you think that you've been unfairly dismissed, especially where you have done the right thing, you provided the medical certificate, you can make a complaint about that. There's a really strict time limit. You've only got 21 days from the date that you're terminated to make an unfair dismissal claim. We recommend you see a lawyer as soon as possible if you think that you've been unfairly dismissed. Your workplace can direct you to work from home or to self-isolate, so long as that directive is lawful and it is also reasonable. So even if they do this, they do still have an obligation to ensure that the work you're doing from home are safe and healthy. So that might include providing appropriate equipment, and also you should not lose any pay or incur additional costs because you're working from home. You can come to us, Barwon Community Legal Service. You could also speak to Job Watch or the Fair Work Ombudsman, and they're all free services.